in my experience in industrial relations, I would have seen many contracts, maybe close to 500 contracts. And what I would say is that I have never seen a contract that is drafted to perfection, right? I would say that. And I would also say that through my observation in industrial relations, what I've noticed is that a lot of the contracts are drafted with just the interest of the employer and not the employee. Now, this session is not a bashing session, right? I'm not here to bash anyone, but I wanted to start by saying that so that we would be jilted into action and correction in how to go about doing an employee contract.
So now, it's a great topic that you just raised there. Can you start with telling us what, because I do know that there are many people who are working and don't necessarily have a contract. What is the importance of an employment contract, both for the employer and the employee?
Well, first we need to differentiate the different types of contracts that may exist, right? Mm-hmm. So we have several contracts, but I would just talk about a few. We have the express term contracts, which is a written contract. And people tend to think that a written contract is more binding than an implied contract, meaning the employer and the employee would have gone into a working arrangement, but everything was said to them verbally. It's not in writing. But the implied contract can be just as important as the express. The disadvantage with the implied contract, though, is that because it's not in writing, oftentimes when an employee finds themselves in a situation where there's a breakdown of the relationship with the employer-employee working relationship, and that employee wants to challenge the employer because there is nothing in writing, we just have to go on the employee's words and the employer's words. We also have what we would consider independent contract. What is that? An independent contract is someone who usually owns their own business and is hired for a contract of service. All right. So that person, while they work for the company, they don't have the stipulations to follow, as opposed to someone who is hired under a contract for service. So there's a contract of service and there's also a contract for service. Then we have the open-ended contract, right? We also have the fixed term contracts, meaning that an employee will be given a certain time to probably complete a job or complete a task. And after that, the employee's contract comes to an end. But with contracts, sometimes it may appear to be something very straightforward. But what we have observed in industrial relations is when in a relationship has broken down and there is an issue where the employee needs to take up a grievance, this is where sometimes the interpretation of whatever contract they were binded to, that is where the challenge comes in. You know, I think that there's a lot of pitfalls in the employers learning how to draft a contract. And for example, we have countries here in Trinidad and Tobago that are also tied to international companies. And what you often find is that instead of the employer drafts a contract tailored to suit Trinidad and Tobago, what they do is they just copy and paste what the international contract has. And that contract is not tailored to Trinidad and Tobago.
Right. It's not governed by our laws.
It is not governed by our laws. And what I would like business owners and employers to keep in mind is whenever they are drafting their contracts, they have several factors to take into consideration. So it is not just a matter of, this is my business and I'm drafting a contract tailored to suit me. What the employer must take into consideration is the laws of Trinidad and Tobago, right? So we have the Industrial Relations Act, we have the Maternity Protection Act, we have the Retrenchment, Severance and Benefit Act, we have the Minimum Wage Order Act. And these are things that employers sometimes tend to overlook. We also have to take into consideration the International Labour Organization, because there are conventions that are also ratified in Trinidad and Tobago. When an employer is drafting a contract, they must also take into consideration the ILO conventions. For example, sometimes you would see in a contract, there's a clause which tells an employee that they are not allowed to join a trade union. Certainly, that is a contravention of the Industrial Relations Act according to Section 72, which gives the worker or the employee the right to join a trade union. Yeah. So I want to also go back on what I would have said in terms of the employer just copying and pasting what they may download on the internet or download from what the international companies that they are aligned to and just put it in a contract. Many times the employees is not explained what is in contract. And I think that the obligation of the employer is when you hand an employer a contract, you must sit down with them and you must have that discussion with them to ensure that they understand each clause in the contract, because that later on brings a lot of contentions where the employee misinterprets certain clause in the contract, and vice versa. The employer may have a clause in the contract that didn't realize that it is going against the laws of this land. Yeah.
Wonderful. That was actually really comprehensive. And I mean, I think it's things to consider. I wonder though if potentially some of the employers can't sit with the employees because they themselves may not know the content of or the importance of what should and shouldn't be in a contract. So you mentioned that there are some factors to consider, and I'm gauging that as the importance of a contract for the protection of the employer and the protection of the employee. Before we get to that, really, when employment exists without a contract, who stands to benefit should the relationship break down, as you phrased it? Who is in a position of power and who isn't? Is that something?
Of course, that is something definitely to consider. As I said earlier, when it's an implied contract, meaning that the employer would have entered into a relationship with the employee just by word of mouth. Long ago, there was a gentleman's agreement where, you shake that person's hand and your word was binding. But because industrial relations in Trinidad and Tobago has now developed into something, the phenomenon of industrial relations in Trinidad and Tobago, you would find that the employee is at the disadvantage and the employer is the one who has that power. Because it is a he say, she say, no, I didn't, no, I never promised you that. The worker can say, no, you told me X, Y, and Z. So what it boils down to, if it reaches a part where the industrial court has to come into play, the court would decide who is actually telling the truth. And besides that, they will now have to examine what the employer is offering in the company, and does the policies that were implemented and so on marries with the laws of Trinidad and Tobago. So if the employer told the employee, for example, that the agreement was that you're not entitled to vacation, certainly if that worker is a minimum wage worker, that is against the law.